Welcome to Citizen Initiatives and Single Amendment Call on Congress for the Sovereignty and State Rights Amendment Convention. Included in the amendment is an historic provision called Countermands, which is the missing piece in the Article 5 puzzle. The call or application on Congress is for a single amendment convention under Article 5 through state legislatures, bypassing Congress, the courts, executive branch, and regulatory agencies. Citizen Initiatives recognizes that state legislatures are sovereign under Article 5 and are the final arbiters in all constitutional matters. Because they are sovereign, delegates sent to the Article 5 Amendment Convention are ambassadors for their state legislatures. They are not free agents. With a separate delegate resolution, the Amendment Convention can be safe, predictable, and successful. The amendment provides countermand authority for states. Countermands are used by state legislatures to counter, disallow, and rescind laws and rulings that are onerous to the states and their citizens. When countermands are issued by 60% of the states, regulatory rulings, court decisions, congressional statutes, and executive orders are disallowed, forcing the government to abandon the law or rewrite it in a manner that is more amenable to state interests. The states will now be seen as a partner with the federal government and shown the appropriate respect. Countermands can be applied to current laws and retroactively. State legislatures can disallow any law or ruling that adversely affects their state and citizens. When the federal government refuses to address an egregious wrong suffered by the people, then the states can force a remedy on the government through countermands. States will now be able to effectively protect their citizens, industries, companies, and resources. Because countermands are part of an amendment to the United States Constitution, they become constitutionally protected rights that the legislatures can exercise without permission from the federal government. State legislators will have an historic opportunity to make a positive impact on the direction of America and their state. Some of the major obstacles to free market growth and personal liberties are regulatory rulings from the EPA, OSHA, DOT, IRS, DOJ, and many other government agencies. Regulatory rulings have severely restricted economic growth. For example, in the healthcare industry, doctors and medical specialists have been prevented from practicing medicine in a free market economy that up until now has been the envy of the world. Consequently, freedom of choice for patients has been restricted, causing a dramatic rise in medical costs while available treatments have decreased. Environmental regulations have prevented Americans from enjoying their real and personal property, which has inhibited many companies from planning and realizing needed economic growth. Intrusive federal regulations have local school boards and school districts violating the constitutional rights of parents. The application of the Commerce Clause frequently usurps the jurisdictional authority of the states and mandates criminal sentencing guidelines that exceed straight minimums. Ill-conceived laws and regulations forced on the energy industry prevent healthy economic growth. The energy industry is the only industry we have that is capable of raising America out of our economic crises and at the same time pay off our $17 trillion debt without government stimulus, new taxes, or borrowing. Growth in the energy industry can be achieved with safe, clean, and efficient energy. The industry itself has the resources to create millions of high-paying jobs, dramatically raise our standard of living, and stimulate many other industries at the same time. The industry also has the will to grow our economy. Congressional statutes often restrict or prevent the exercise of our constitutional rights. Examples of restricted congressional statutes are laws that withhold funding to the states when they refuse to follow congressional mandates in education, the environment, health care, transportation, etc. Laws that impose on doctors and the healthcare industry regulations that prevent the practice of free market principles by medical professionals, resulting in higher medical costs and fewer treatments. Laws that tax the people, forcing them to purchase government-mandated health insurance. Laws that place onerous regulations on the trucking industry, resulting in higher costs for America's products, while restricting drivers from pursuing productive livelihoods. Laws that place on public education federally mandated rules that deprive parents of their constitutional rights to raise their children according to their faith and conscience. Use of the Commerce Clause that usurps jurisdictional authority of the states and mandates criminal sentencing guidelines that exceed state minimums. Supreme Court decisions often change state laws without approval or ratification by the states. Examples of Supreme Court decisions: in 1962, the Supreme Court ruled that a non-denominational prayer in public schools was unconstitutional. In 1963, the Supreme Court ruled that allowing Bible reading in public schools is unconstitutional. In 1973, the Supreme Court ruled that a privacy right existed that gave the mother of an unborn child the right to kill her child with impunity. Up until 1973, every state had laws that protected the unborn child's life. 7 justices in Roe v. Wade changed state laws and, in effect, amended the Constitution without ratification by the states. Consequently, 50 million or more unborn children have been aborted over the last 40 years. Over $18 trillion in taxes have been lost to the states. The losses to the states in human lives and resources are incalculable. Executive orders and Department of Justice lawsuits are often intended to restrict the constitutional rights of some in favor of a political objective. A recent example is the excessive delay caused by government regulations that has kept the Keystone Pipeline from being completed. With Countermands, the federal government will be forced to have a more amenable attitude toward the states before they enact egregious laws and regulations. For the last 50 years, government has allowed foreign governments and companies to enter American markets and copy or even steal our industrial might, technology, medical innovations, even national security secrets. The only industry that no one can steal from us is the energy industry. Our natural energy resources are domestic and nearly unlimited. However, because of restricted ideological rulings and laws, the energy industry has been prohibited from applying free market principles. Environmental rules and laws have crippled the industry and prevented it from developing clean, safe, and low-cost energy for America. These prohibitions have also crippled many other industries, preventing the creation of wealth that is essential to all Americans for higher wages and economic security. By developing domestic energy, we reduce imports, thereby keeping needed capital and jobs in America. Almost all industries will experience dramatic growth as a result of the full utilization of our energy resources. Greater exports will also help balance trade deficits and create more tax revenue for the government, which will reduce our national debt and help balance our federal and state budgets. Countermands can make the states partners in government, enabling them to protect the interests of their citizens and industries. With Countermands, we can climb out of our economic crises and pay off our $17 trillion debt without a government stimulus, without new taxes, without borrowing, and at the same time significantly stimulate economic growth in all industries: manufacturing, wholesalers, service industries, physicians, medical specialists, healthcare facilities, transportation, technology, etc. Countermands can create new jobs, higher wages, and higher standards of living for all Americans. Imagine, our children and grandchildren could be debt-free in 20 years. Whenever government refuses to address an egregious wrong suffered by the people, countermands can remedy their grievances peacefully. Examples of grievances that can be disallowed with countermands: excessive taxes, laws that prevent the healthcare industry from innovation and growth, social issues, transportation industry, land use restrictions, workplace rules, energy prohibitions, federal education mandates on the states, and more. Countermands can restore states' rights, stop government encroachment on states' rights, disallow adverse rulings from the EPA, OSHA, executive orders, etc., rescind adverse laws, congressional statutes, court decisions. With countermands, the 50 states become genuine partners with the government. Congress, the courts, executive branch, regulatory agencies will be more amenable to state interests when making laws. A completed countermand requires 30 state countermands to disallow laws and regulatory rulings. Countermands disallow and rescind onerous laws automatically and immediately. Countermands can be applied to current law and retroactively. Countermands are part of the Article 5 call on Congress by state legislatures for the Sovereignty and State Rights Amendment Convention. This call will be a single amendment convention with other subjects in the amendment, such as sovereignty, martial law, or privacy in the age of technology. State legislatures will limit the convention through a delegate resolution that binds the delegates to a pre-approved text of the amendment at the convention. 34 states have to make calls, called applications, directing Congress to convene the Sovereignty and State Rights Amendment Convention. When 34 states complete their calls, the applications become mandates, requiring Congress to convene the convention. 26 delegate resolutions must be approved by state legislatures, so the convention can be organized by the delegates sent to the convention in a manner required by the legislatures. Delegates to the convention are ambassadors of their state legislatures. They are not free agents. 38 state legislatures must ratify the Sovereignty and State Rights Amendment before it can become part of our Constitution. Because the Sovereignty and State Rights Amendment allows states to countermand laws and regulations that adversely affect them, state legislatures see the amendment as an important vehicle that balances the rights of states in our constitutional republic, while at the same time allowing the federal government the necessary authority it needs to conduct the nation's business at a national level. Remember, 60% of the state legislatures are needed to countermand any law or regulation before it will be disallowed and rescinded. The federal government then has the option to rewrite the law so it is more amenable to the states. The government can also opt out and allow the rescission to stand. Intentional violators of the amendment are subject to both federal and state prosecution. The federal government can prosecute violators at any time. However, if after 90 days the federal government has taken no action, but a state has, then the federal government is prohibited from initiating a prosecution after 90 days. The states can prosecute intentional violators under state laws after 90 days from the alleged violation. Those subject to criminal prosecution for intentionally violating the provisions of the amendment are elected officials, government employees, private organizations, and individuals. If you are a legislator, you can download a copy of step-by-step instructions for completing a call directing Congress to convene the Sovereignty and State Rights Amendment Convention. Go to citizeninitiatives.org/legislators step-by-step.pdf. If you are a sitting legislator and would like to be a member of the Legislative Amendment Committee, email us at director@federalconventions.us. Citizens wanting to help secure the call on Congress for the Sovereignty and State Rights Amendment Convention can consider these opportunities: regional directors, legislative directors, state directors, and state coordinators. Contact us at director@federalamendments.us. Our website, citizeninitiatives.org. Welcome aboard.